Welcome to this online training resource module on data processor obligations from Muckle LLP. There are some references to the Data Protection Act 1998, but this module concentrates mostly on the General Data Protection Regulation. My name is Stephanie Coulson and I'm an Associate Solicitor in our commercial team. I specialise in data protection. If you find this module of interest, then please get in touch to see what other modules are on offer. A data processor is a natural or legal person, public authority, agency, or any other body which processes personal data on behalf of a data controller. We'll take a look at some examples on the next slide. The distinction is really important so that you can understand what your liabilities are under the Data Protection Act 1998 and under the GDPR. Under the Data Protection Act, there are no liabilities placed directly on data processors, but this is changing with the GDPR. And this module outlines the obligations on data processors and the matters that need to be included in any contracts between data controllers and data processors. As I mentioned, we have a few examples here on screen. It's really important to identify who is the data controller and who is the data processor for the purposes of compliance with data protection legislation. If you outsource your payroll, or if you have a CRM solution which manages your data, or if your school which has a music or sports tutor, those organisations or individuals are your data processors. This is equally important if you're a data processor, so that you can understand what your obligations are and you can adequately protect against your risk. Data processors need to have regard to the concepts of accountability, privacy by design, and risk assessment when designing and offering their services. Accountability is the new data protection principle under the GDPR. Data processors will need to consider how their service and contracts help support compliance with this principle. Privacy by design is also a new concept under the GDPR. This requires data controllers to consider data protection when deciding to implement new services. It therefore follows that data processors need to be able to demonstrate compliance with the GDPR and to demonstrate robust mechanisms for the security of personal data to assist in winning new clients and customers. Linked to security, it's also useful to carry out a risk assessment on your service offering to see what improvements can be made. This again will help with winning clients and customers. Some data processors will be required to appoint a mandatory data protection officer. It's worth having a look at the Article 29 Working Party guidance in relation to data protection officers. Under the GDPR, you're required to appoint a data protection officer if you are a public authority, if your core activities require regular and systematic monitoring of data subjects on a large scale, or if your core activities involve large-scale processing of sensitive personal data, soon to be called special categories, and data relating to criminal convictions. If you have to appoint a data protection officer, then there are certain requirements that need to be in place. For example, they must have the sufficient expertise and they must be independent. Direct security obligations are imposed on data processors under Article 32 of the GDPR. This also includes a requirement to inform data controllers of security breaches. Security has always been on the radar of data processors, mostly because of Principle 7 under the Data Protection Act 1998, which is included in contracts between data controllers and data processors. There will no longer be simply a contractual remedy for data controllers against data processors. Rather, now there'll be an obligation direct on data processors to ensure that their systems and their services are secure. There is also a requirement under the GDPR for data processors to inform data controllers of security breaches. This is to assist with the new statutory requirement for data controllers to report breaches to the ICO where they are serious within 72 hours of becoming aware of them. Contracts. Data processors need to have a written contract with data controllers for whom they process data. This is an absolute must under the GDPR. It's no longer best practice or simply the means to include Principle 7 wording. The GDPR envisages that model wording could be made available, although as of October 2017, this is not yet available. The GDPR also considers a certification system where data processors could be vetted and sign up to a certification demonstrating elements of compliance. Again, as of October 2017, this has not yet been developed, but do keep an eye out. There are now some specific matters which have to be included in such a contract, which we'll run through. The first one is the subject matter and duration of the processing. The second is obligations and rights of the data controller. The third is confirmation that the data processor will only process on documented instructions from the data controller. The fourth is to include an obligation on the data processor to ensure that anyone authorized to process data under that contract is committed to a confidentiality obligation. The fifth is reference to compliance with security measures. The sixth is confirmation that the data processor cannot appoint a sub-processor without consent, and that obligations will flow down into any sub-processor contracts, and a clause confirming that the data processors will provide supporting information to demonstrate compliance. The seventh is confirmation that the data processor will assist the data controller, for example with data subject rights. The eighth is details of what happens to the data at the end of the contract. And the ninth is confirmation that the data processor will assist in contributing to the data controller's audit. So you must ensure that you have contracts in place and that they cover all of these elements. A separate and again new provision of the GDPR requires data processors to keep records of their processing activity. Overseas transfers. As you may be aware, there are currently restrictions on the transfer of data outside the European Economic Area unless certain protections are in place. Those are that any transfer has to be a country that has adequate data security measures in place, and the ICO has a list on their website of which countries they are, or the country or organization to which you're transferring data must have model clauses in their contracts, or in the case of transfer to the USA, they must have signed up to Privacy Shield. These restrictions under the GDPR will apply to data processors as well as data controllers, so you need to understand where data is held and where it's transferred to. This you can identify when you're carrying out your risk assessment, and this will ensure compliance going forward. Cooperation. Data processors must cooperate on request with supervisory authorities. We've put on the slide there, for example, the ICO. The ICO is the supervisory authority in England and Wales. However, this requirement also extends to compliance with other applicable supervisory authorities. Data subjects. Data subjects will be able to complain directly to the ICO about data processors, and of great concern to data processors, the ICO can fine them for breach of their obligations. Data subjects can also bring court claims against data processors. This is absolutely key. If there's a data breach or a data loss and individuals are affected, they can now also pursue the data processor rather than simply the data controller. And the ICO will be able to levy fines against the data processors direct. Their fining capacity is significantly increasing. We hope you found this module on data processor obligations useful. If you have any questions or would like to know more, please get in touch with me or a member of our team. If you're interested in our other modules, then please also contact me or a member of our team. Thank you.